Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Hell no.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell. I don't understand none of this, what he thought. And it's a conspiracy between these two right here.
Listen, Mr. Cromartie. Mr. Cromartie, what do you?
Man, I don't understand, sir.
I don't believe you, Mr. Cromartie, because you act like you do understand it.
I don't understand, sir. Yeah. First of all, I have the right to face my accuser.
What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Then yes, you do understand you have a plea offer for 25 years in prison.
All right, everyone. Today we're looking at a courtroom case involving a man who identifies as a sovereign citizen and is facing 2 life sentences. Yes, 2. What makes this even more surprising is that he struggles with reading and writing, yet he insists on representing himself. As you can imagine, that decision does not work out well. The judge stays firm and doesn't entertain any distractions. When the judge asks if he understands a 25-year plea deal,
no, Mr. Salim represents either one of those.
Mr. Salim?
Mr. Salim, can you join us?
Hey, Your Honor, can I speak for the record too?
Williams, finish knowledge.
Yes, sir.
So I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that. But considering the fact,
Your Honor, this man ain't even helped me in my defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
What I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365. The attempted murder case is a life sentence, in that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right, he's choosing not to do that. But I did want that on the record so that there was no confusion later on about whether or not I had informed him of the offers and how I advised him and that sort of thing. So,
Your Honor, my intention is to revoke those offers today, and I plan on moving forward next week. One thing that Mr. Williams mentioned, yesterday I filed the HBFO notice, which actually extends his exposure in the tampering case from 30 years to possible life in that case as well. Okay. So the maximum that Mr. Cromartie faces is 2 life sentences consecutive.
Okay.
I really wasn't aware of that. You hear what he said?
Yes, sir. But
so let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being him, being that he's representing me, we haven't even worked the defense in this case at all, period. Okay. And plus,
let's take one thing. Do you understand that you've been offered 25 years in prison?
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
I don't understand because I'm innocent. I don't know what's going on.
Listen, you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum
mandatory minus the time you served in jail. No, I just need you understand that's the plea offer from the state.
Hell no. I don't understand none of this, what he talking, and it's a conspiracy between these two right here.
Listen, Mr.
Man.
Cromartie, Mr. Cromartie, what do you?
Man, I don't understand, sir. And
I don't believe you, Mr. Cromartie, because you have.
You can almost see him freeze. It's like he's hoping that by acting confused, the court will give up and let him off easy. But that's not how it works. If someone claims they don't understand what's happening, the court orders a competency evaluation. Professionals step in to determine whether the person is truly confused or just pretending. If it turns out someone is faking, it only makes things worse. This man is facing 2 life sentences in a row. With that much at stake, it's clear why he's under pressure. Still, refusing a 25-year deal and playing confused is a risky move. At some point, personal responsibility matters. It's hard to tell whether he truly struggles with literacy or if he's trying to avoid the consequences of his actions. Either way, the judge handles it calmly and by the book. Courts don't simply drop a case because someone says they can't read.
What are you asking for right now? What are you asking for?
I'm asking for him to be removed off my
Raise
case.
your right hand to be sworn.
I do.
Wait till the oath is done, sir. Do it again, madam.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but it. I hope you got it.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Jamel Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamel Cromartie, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my 4th and 5th Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my 5th Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr. Cromartie, what are you asking me today? I'm gonna give you one
I
more
don't
chance.
need him on my case.
Okay, are you at, listen, what are you asking me to
Or
do?
this one right here. This both them two right there.
Okay,
I got some that's conspiracy on what they trying to do.
okay, what do you want me to do?
Continue my trial.
No, sir, motion denied. What are you actually asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right now, you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself or are you gonna hire another attorney?
I'd rather represent myself to get an attorney.
You already sworn in, so state your name again.
Jamel Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week, is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay. Do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court, is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that, is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest and that would settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
There's
correct?
a lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court, is that correct?
I'm not gonna say I'm being truthful.
When you
I
said
don't understand.
you don't understand.
You got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't
understand.
understand because there's some shit.
So you
that's
don't
going on.
you don't understand what's going on?
Half of it I don't.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell.
Okay. And do you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did?
do what I can that I've been trying to do.
Do you understand you'd have to do
I do
everything?
better than him.
Listen to me. If you want to represent yourself, you got to answer these questions. If not, I can't allow you to represent yourself. So,
I ain't trying to make a fool of myself, but Yana, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're going to pick a jury Monday morning. I'm not continuing the case. And you're going to try the case next week if you represent yourself.
Okay.
And you read and write.
If literacy is a real issue, the court can appoint an attorney, bring in evaluators, or have documents read aloud. What they won't do is dismiss serious charges based on confusion alone. If this goes to a jury trial, it could end very badly for him. I'll share the second hearing if I can find it, because it adds even more to the story. In the next hearing, we see another defendant who keeps arguing about bond. The problem? He was already given bond once, released, and then committed another crime. Bonds aren't automatic.
You don't have time to learn, so you can barely read and write. Is that correct? You don't understand about the plea offer. You understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm going to find that you're not competent to represent yourself. Mr. Salim will stay on his case. Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury. All right.
Judges consider past behavior, the seriousness of the charge, and whether the person followed the rules before. In this case, the judge's decision makes sense. Both hearings show the same lesson. Pretending not to understand the law doesn't solve anything. The legal system has procedures in place, and judges rely on facts, not frustration.
Well, Mr. Clark, can I say something, sir?
Yeah, you can address, yes, sir, address your case also, the one you're representing yourself also.
Right. Yes, sir. On that case,
That's for the record, that's 23 CF 204.
yeah, well, I got a couple motions I want to file on that one, but
Okay.
about that case, so can I ask why am I being held without bond?
Sir, Mr. McCoy, we've gone over that. I revoked your bond, I believe, in the K2 case numbers because of the arrest. So I think we've already adjudicated that and litigated that. I'm gonna litigate it, but that's why you're being held without bond.
I mean, is there a reason though, sir? Like,
Yes, sir,
reason
because
to be held without bond?
yes, because you were out on bond and you picked up another charge.
But I'm innocent on that charge, Mr. Clark. And I got the evidence.
Absolutely, you're presumed innocent on all the charges. So I assume you're not admitting that you're guilty on the two charges that you're out on bond on. You're presumed innocent on all three of the charges.
Can I ask that the state has filed a motion to hold me without bond, Mr. Clark?
No, sir. I believe the court, and I may be wrong. I may have done it on my own motion.
You had a hearing in February, I believe it was February 24th, and then you addressed it also at our last hearing on October the 17th.
There was an order of revocation of release, and that was done by the first appearance judge on January 18th. So that judge held a hearing and revoked your bond or issued basically a warrant and held you without bond. So that, and I upheld that.
I understand, sir, but it's been since January. Is there a reason why you feel like I need to be held without bond?
Yes, sir, because you picked up another charge while you were out on bond.
Well, Mr. Clark, I'm just speaking real quick.
Go ahead, do it quick. I've already addressed that. I'm not making it any plainer for you.
Have a little patience with me, sir. I understand that's judges. They should be patient with their client, with litigants.
Well, I'm as patient as you. I'm gonna be patient. I'm gonna treat you just like a lawyer. And I'm treating you just like a lawyer. And when a lawyer goes to repeating themselves or re-litigating something that's already been litigated, I give them very little short leash. And that's basically what I've done to you. I've addressed that so many times. I'm not prepared to address it again today. So if you want to talk about something else, let's move on. But I'm not going to reinstate your bond today. Okay?
Actually, why, Mr. Clark?
Watching people make poor choices in court can be frustrating, but it also shows how important it is to take the process seriously. I'm especially curious what you think about the first case, given that he's facing 2 consecutive life sentences. Thanks for watching, and I'll see you in the next one.